Good morning.
Good morning.
Hello there. Hi, I'm Toby from Ealing and Hounslow CVS. Looking at the names, I think I had a couple of people coming through. I probably met quite a few of you before. So thanks for joining. Lovely to see you. So yeah, this is the training about Hounslow's housing allocation policy, and it is with Vicky Fewkes from Ealing Law Centre, who's here and is going to deliver the session. So I'm just going to let a few more people in. I'll just give it a couple more minutes and then we can start. So there was a session yesterday that was for Ealing, regarding Ealing's policy, and I followed up with all the relevant documentation. So I'll be doing that the same for this session and also recording it, because I've had a couple of people saying that they're interested to find out more but couldn't make it. So yeah, this will be recorded, which is really valuable. And I'm just looking at the chat, and so we've got someone who said they've lost their sound. We need to log in and again. Okay, I will keep an eye out for that person in the waiting room and I'll let you in again. So yeah, if everyone can just keep their microphones on mute, just whilst Vicky's talking, and then obviously there'll be plenty of opportunity to ask questions, and when you do that you can introduce yourself and say a little bit more about your organisation. But okay, over to you, Vicky.
Hello everyone, hi. Nice to see some of you and sort of see some of you behind your cameras. It's great to be doing this session on Hounslow's allocation policy. I did a session yesterday, as Toby said, for Ealing, and actually Hounslow's policy is quite different in some ways, so it's very interesting to have looked at the two. I've got a PowerPoint of slides to go through with you, and I can send those across via Toby when we've finished. It's quite a nice size group, so if you do have questions as I'm going through, I'm really happy for you to just sort of stop me and ask questions as I'm going along. I might not know the answers, I might need to get back to you, but please do stop and ask me anything. And I'm really happy for it to be as interactive as possible. I've got several slides, and then I've got an exercise, an example to kind of hopefully work through together, just to kind of get us thinking about how this works in practice and how we would be advising clients. I'm going to share my screen, and yesterday this worked quite well. I'm hoping that today it will work as well, but let's see how we go. All right. Okay, so we've got here the Hounslow allocation scheme. Can everyone see that? Yeah, brilliant. Okay, so in terms of the aims of today's session, what I'm going to look at today is a broad overview of the allocation scheme and look at some practical general advice about the situations. And what I'm not going to do is I'm not going to give people advice individually. If you have individual questions or your own personal circumstances or a particular client, I'm happy for you to email me. I've got my address at the end of the PowerPoint presentation, but it's not a good idea to discuss that sort of in public, but I can speak in general terms. And the other thing is I'm going to look at the law of the scheme and the practical application rather than the politics of it. I'm a lawyer, I have my views about the politics of these things, and yes, we should all be having more council homes, and yes, everyone should be entitled to good, safe housing, and we shouldn't have lots of private rented accommodation, but that would be a whole other presentation, and not for this session. We're going to look through Hounslow's allocation scheme. What's interesting about Hounslow is that it's based on direct offers rather than a choice-based letting system, which Ealing has. So actually that's quite interesting and a change from what's happened in previous years. I'm going to look at the differences between the policy and homelessness applications and the importance of trying to work out where your client is in that process. I'm going to give you some practical examples and then also just chat a little bit about when you might want to get some legal advice or legal aid for your clients, you know, when it gets a bit more complicated. So the first thing is really, what is an allocation scheme? You know, we talk about an allocation scheme, but actually quite a lot of people, I think, would even struggle to know what was meant by that. They might think, oh, well, we know about a waiting list. People would often sort of describe an allocation scheme as a waiting list. But for many years now, each local authority has a duty to have a policy, an allocation scheme about how they will allocate their accommodation. And the council can only allocate in accordance with their scheme. So, for example, if you had a horrific situation where a housing officer was friends with the person around the corner and they made an application to the scheme and they gave a property on the scheme, that would be unlawful. And there have been some horrible cases down in South London where things like that have happened. But there's a whole section in Hounslow's scheme about, you know, if you know someone from the council, you need to declare that. So each council must have a policy in accordance with the scheme. And in that policy, they should give what's called reasonable preference to certain groups of people. So, for example, in terms of the reasonable preference, there should be reasonable preference given to those who are owed duties by the council because they are homeless. So, for example, those that are homeless, eligible for housing assistance and in priority need. And also those who have been found to be owed the relief duty under the Homelessness Reduction Act. So those who are homeless. Other groups would be including those who have medical needs, care leavers, and those who are nominated for emergency transfers. So they're the groups where the council have decided that they should be given a reasonable preference. That doesn't mean to say that they should be given council housing. It just means that in the way that the policy is allocated, they should be given a reasonable preference. And the place that this law all comes from is the Housing Act 1996. So if you want to know anything about how the council should be dealing with the homeless population, people in temporary accommodation, it will be dealt with in the Housing Act 1996. And there are two main parts that housing lawyers use. The first is Part 7, which explains the local authority's duties to those that are homeless, and whether or not someone is owed that duty. And then Part 6, which deals with the allocations and the waiting list. The reason that I have put this on this slide is that if someone comes and is seeking advice, it's really important to distinguish where they are in the process. So, for example, if you're freshly homeless, the council may have put you in an interim accommodation to assess your situation. You will be being housed under Part 7. If, for example, the council have decided that they owe you a legal duty, then you're probably being dealt with under Part 6. And there are some places where those duties overlap. So once you are accepted as homeless, in Hounslow, you're placed on band 2 of their allocation scheme. So sometimes someone will come and say, oh, I've been placed in private rented accommodation, but Hounslow are my landlord. And you sometimes have to try and unpick that, because Hounslow will have arrangements with private landlords to put clients in temporary accommodation. They will also have arrangements to end their legal duty to make an offer of private rented accommodation to clients. So quite often when you're seeing someone for the first time, you're trying to dig down to work out in what way they're being accommodated by the council. Oops. So as I said, in Hounslow, one thing that's very different from neighbouring Ealing is that there's no choice-based letting scheme. So it's not a scheme where you log on every week if you've been accepted on the register and bid for accommodation. It's a scheme where you are made one direct offer of accommodation based on the information that Hounslow has on the record for you. And interestingly, when I was looking into this, what the policy reason behind this was that there's so few available council lettings or housing association lettings in Hounslow that they thought it was a more realistic way of dealing with lettings than having a choice-based system which actually doesn't provide any choice. So one of the complaints you get in Ealing quite a lot is, I've been bidding, there's no 3-bedroom homes, I'm not going to be able to get anywhere. Whereas in Hounslow, you're not seeing that. The only time you're being contacted is if you're contacted with an offer of a direct offer of accommodation. And the scheme does say that only 2 in 10 people in a year will be made an offer of, 2 in 10 people, I think, that are on the register would be made offers of social housing. So that's really, you know, a low number. And I think probably because of this, and in another way which makes it quite interesting and different from Ealing, is that they've private rented offers. So for example, if you're accepted as homeless and the council accept they had a legal duty to house you, but they can comply with that legal duty by giving you an offer of private rented accommodation, the way in which those private rented offers are dished out, they're included in this scheme. It's also very clear from the scheme that you need to, that the responsibility is on the client to update the system, which is an in-house system, with any changes in their circumstances. Now, I think this is doubly important with Hounslow compared to Ealing, because in Ealing, you will be bidding and you will be making a choice. Whereas in Hounslow, if you're offered, you're going to be offered something on the basis of what's on the system, Hounslow's internal in-house system. So you need to make sure that that system is up to date. And, you know, if there are changes in the family, if there are additional children, additional medical needs, you need to be making sure that, that those needs are set out on the system. The only time, from reading the policy, the only time you're likely to be made more than one offer is for example, if you're downsizing. So there's an incentive for families, sort of places where families have grown up and maybe there's a couple occupying a 3-bedroom home, and the council are quite keen to free up larger properties. You might then be offered different, you know, more than one offer because it's you who's deciding actually you want to downsize.
Really?
Yeah. So I think that's quite interesting. Oh,
Zoom.
okay. So what is good about the Hounslow policy is that it's actually very clear and it's a very detailed policy. I think it runs to 72 pages, but they do actually have on their website, and I've given the link a little bit later on, a very detailed frequently asked questions section. So people
Everyone
can
just make sure their microphones are on mute, please. Thank you.
Okay, yeah. So you can find out quite a lot there on the frequently asked questions section of the website. Does anyone have any questions so far? Anything that's not clear about this, about what I've said so far? Okay, all right. Right, so Hounslow's policy is split into 3 priority bands. The first priority band is band 1, which is that there's a high priority to move. And there are various reasons listed in the policy about why you might have this high priority to move. And in terms of medical, you have a high priority to move where the applicant has a life expectancy of 12 months or less, and rehousing is required to provide the basis of suitable care, or the applicant's health is so severely affected by the home that they currently occupy that it's likely to become life-threatening. So that isn't just, I can't get up the stairs. It's, you know, a serious, very, very serious situation. I've had situations where with Hounslow, if someone's in a tower block and they're actively suicidal, and the mental health trust have thought that it's actually, you know, dangerous for them to be there, that's a situation that would be a band 1 priority. So other reasons for band 1 priority is that the applicant is housebound in their current home and needs to move to get a home that's suitable for their needs. And if there's exceptional needs, there's a panel where cases can be referred to. So in terms of other reasons, you've got overcrowding. So that is, you could be lacking 3 or more bedrooms to be in the highest priority. So that's not a little bit of overcrowding, that's your actual bedroom allowance is 3 or more bedrooms. And in terms of property conditions, the property is in such bad condition that there's no prospect of it being resolved, or that the property is going to be demolished. And again, that's not that there's a bit of damp in the property, that is, it's a very serious high level disrepair, and that or Hounslow need to decant. So what a decant is, it's when they permanently move council tenants into another block, or that you're in an adapted property and you're under occupying. So sometimes you get situations, for example, there's been one member of the family that had maybe a wheelchair adapted property and has sadly passed away, and there's someone else in that property who now doesn't need that wheelchair adapted property. They would be put on the highest band because it would be in Hounslow's interest to try and get someone else who desperately needs a wheelchair adapted property into that property. So it's not that that person would desperately want to move out, and probably they wouldn't want to move out, but it's about them trying to manage the situation in their properties. So that's the high priority to move, band 1. The second band is that the applicant's housing is unsuitable due to severe medical needs, which significantly aggravate the medical condition of the applicant or their household, but is not life-threatening. So it's severely aggravating, but it's not quite at the same level as the life-threatening condition. So this is where okay, I've put that twice. And then there's again an option to refer to an exceptional needs panel. You have again a section for overcrowding. So if you're lacking 2 or more bedrooms, or if you're missing a bathroom, kitchen, or heating and hot water. So, I mean, if you think about this, it just shows the sort of level of need in the borough, that if you were missing a kitchen or bathroom facilities, according to this policy, you're not even going to be in band 1, you're going to be in medium priority to move, which I think is actually quite shocking. Or you need to be decanted in 6 to 12 months, or you're accepted as homeless. So I don't know, I haven't got a breakdown of the numbers on the Hounslow Housing Register, but certainly in Ealing, that this category here of people who've been evicted and who Hounslow have accepted a legal duty to house makes up a lot of the band 2. People looking to move to supported housing, and also those leaving care. And one of the things that I think people have found quite difficult about Hounslow's scheme is that in quite a lot of other schemes there is sort of recognition that care leavers would go automatically to housing association or council property, but actually in Hounslow there's quite a lot of offer of private rented accommodation with care leavers. Does anyone have any questions about those sections? No? Okay, I'll move on then. Right. So then we come down to the lowest band. We've got a low priority to move. And again, we have the medical section. So where the home currently occupied by an applicant aggravates their medical condition. There's exceptional need, but low priority. You've got a low income and overcrowding, and they lack at least 1 bedroom. This is an interesting one, which again isn't on Ealing's, which is a verified rough sleeper. So someone that one of the outreach teams has verified as sleeping rough. Those who have moved that need to move to Hounslow from other boroughs to work. Those who are homeless but not in priority need, and some households that have been placed in Hounslow by other boroughs when homeless but need to stay in Hounslow. So this is quite, I mean, this band 3 It's the lowest, obviously it's the lowest band. It will include people then being offered private rented accommodation because that's included in this scheme. But it takes into account some of the things that happen in other boroughs but aren't covered by their scheme. So for example, in Ealing, it's quite, that their Thames Reach team will assist rough sleepers into private rented accommodation, but this is actually set out in the Hounslow scheme. Okay, so I think when we're dealing with clients, the most common query that you get is about the medical banding. And one thing when you're looking at this is, if you look here, you've got band 3 medical needs, but in band 2 you've got accepted as homeless. So if I just go back here, you've got homeless families accepted as homeless, and band 3 you've got medical need. So occasionally you'll have a situation where the homeless client is saying, well, I've been accepted as homeless, but I also have medical conditions, can I go up a band? And unfortunately, often that's not possible, and actually would not really be worth investing that time in trying to get them up a band, because in band 2, they're already in band 2 because they're homeless. And actually, unless they've got the severe, the property is significantly aggravating the medical conditions, they're not going to be moved up. So, common queries. This is the bit where I rant about doctors, so I hope no one's on here is a doctor or medical advisor. What Hounslow will do, and actually they've set it out really well in the policy in quite some detail, is that if people have a medical need.
Where do you click then?
Hi, could we just turn the microphone off? Put it on mute. Thank you. Oh, thank you. So if someone does have a medical need, it will be referred to the council's medical officer, and that will form the basis of the council's decision about whether or not there's any movement in band. The medical officer won't usually see the person. So what I've put here is, if you're in a situation where you're advising someone and you are trying to get them to move up into band, either band 2 or band 1 because of their medical conditions, it's usually really important to get independent medical evidence. And the evidence that you want is the link between the conditions at the property and the person's medical conditions. So it's really important that you give your clients, either that you write to the doctor and request the medical evidence, or that you give your clients some very clear instructions about what it is they're asking for. Because if you're not careful, what can happen is people will say to their doctor, I need a medical letter for the council, and the doctor will write, this pleasant lady came to see me, she would prefer a house with a garden and a council property. And yes, that would be nice, and I'm sure we would all prefer something like that, but it's not setting out what the medical condition it is. It's not setting out what the effect that the current property is having on the medical condition. And if you're going to get anywhere with a review or with getting someone up a banding, you really need to get that. And the other thing is, sometimes doctors will say things like, oh, someone has a preference for this, or they would benefit from the children are really struggling, they're in a 1-bedroom flat with 3 children, they would benefit from bigger accommodation. That's not really going to help you very much. But if it was a situation where maybe the child had special educational needs, maybe they have ADHD, which means that they're in 1 bedroom and that's a complete impossibility, and you have someone that maybe a social worker or an occupational therapist that has actually been to see the property and can give a detailed report about the effect that the property has on that child's health, then you're going to get further. So the procedure for all of that is set out. I'm going to send the policy around. It's on page 52, and also it sets out quite clearly different bands for mobility, which I thought was quite interesting. So there's this, a section, if you're a full-time wheelchair user, if you need wheelchair every now and again, and it's very clear there about how they allocate. Has anyone got any questions about medical evidence or anything?
Yeah. Hello, good morning.
Hi.
Yeah, I have applied for the council house, and at current we are living in a one single bedroom, and my son is a Down syndrome boy going to full day school, so he have lot of medical issue. So we are living in a small bedroom. I have applied for the OT report also for my housing. So now at present, I didn't hear anything about from the housing. I'm waiting for the house. My son is open heart surgery. He's now 17 years old. Then we have his left eye is very weak. He can see only 6 meters.
Umesh, I'm just going to stop you there, because what I don't want to do is I don't want to go into the people's personal situations. What I've done is I've got my email at the bottom of this. Okay, so I'm very happy to have a chat with you about it, but let's do that somewhere a bit more private.
Okay, yeah.
And also maybe there's some groups on this call who could support this lady as well. So maybe if you want to put your contact details, if any of your groups are able to help,
yes,
you can drop that in as well. Okay.
Yeah. Can you please give me a contact detail so I can talk to you straight?
I've got them at the end of my presentation, so we will send you these anyway. So
okay, yeah.
Okay.
Yeah.
Okie doke.
Yeah.
All right then. So, okay, there we go. I've put an OT report on there next. In terms of moving and evidence, that quite often it's the occupational therapist that will go and assess the property. So it tends to be good evidence. The environmental health officers, they might also serve improvement notices if the property is not in a good state. So quite often when the officers are assessing this, they will look at what can be done in the property itself. So if there's disrepair, they will be looking to try and use their powers to get the landlord to fix the disrepair rather than making a further offer. So if you remember, if we go back to the bands, band 1 or 2, they're looking at properties that might need to be demolished when they're looking at disrepair. Then and in band 2 was looking at properties that didn't have heating and hot water and bathroom or kitchen. So they're keen to try and get landlords to improve properties in the meantime. So in terms of home seekers and people being accepted as homeless, one of the issues that sometimes arises is that if you've been in temporary accommodation, you may have rent arrears that have arisen from that temporary accommodation, and that could then block an offer of permanent housing. So I think it's really important if you're in temporary accommodation and you've got rent arrears to seek some advice about that, to see if you can make any applications for discretionary housing payment, see if you can make sure that you're claiming all the welfare benefits that you're entitled to. And there's a very strict process with Hounslow about when you're made an offer. So if you're made an offer, they expect you to be able to sort of verify yourself, so to speak. So they want to see, evidence that you're eligible. So in terms of immigration status, and also that you go to the appointment to view the property. And it's really strict. So what they say on their policy is that if they make a direct offer, so if you're contacted by Hounslow Council and they say, we're making you one direct offer, the only excuses that they're going to accept for you not going and doing that is if there's something life-threatening that means you can't do it. I'm not quite sure whether or not they've softened that due to coronavirus, because you would have thought that, a situation where you potentially had symptoms of coronavirus, that they would excuse you not going and viewing a property, or they'd do virtual viewings. But it's really important that if they make a direct offer that you view. And one of the reasons for that, and possibly the most important reason for that, is if you are accepted as homeless. So say you were evicted from your private rented accommodation, you went to Ealing, Hounslow, you went to Hounslow and they put you in temporary accommodation. You're in your temporary accommodation, and then Hounslow say, right, we're going to comply with our legal duty by giving you this offer of a private rented tenancy for a year. Here's the address, we want you to go and view it. We think it's suitable with the information on our system. And if you refuse it, we will end our legal duty to house you. And unfortunately that happens, and it puts a lot of pressure on people because they've gone to view something, they don't think it's suitable, but the council have ended their duty. And what you can do with that, if you're ever in that situation, you do need to seek legal advice, because what the legal advice will generally be is if you're offered something and you're told that if you don't accept it, the legal duty will end, what you need to do is you need to accept it, and then you can request a review. So there's a situation where you can protect your position. You can go and view it. You can say, well, it's not suitable for X and Y reason. You can accept it, and then you can request a review. And the good thing about that is that Hounslow will then still have a legal duty to accommodate you. They're not going to end that legal duty. So in any situation where Hounslow is saying, look, this is a direct offer and you're in homeless accommodation, it's really important that you view and that you seek advice if it's not suitable. And I know what happens and what tends to happen is that this all happens very quickly. So people could be in temporary accommodation for quite a few years. Suddenly they get a call and they're told that they need to go and view accommodation that they've not seen before at all. And people can panic and turn something down because they're just in shock that this is happening. And then it puts you in a really vulnerable legal position. So if anyone finds any clients in that position, it's really, really important that they seek legal advice. Okay. So has anyone got any questions about that? Okay then. So I'm going to move on to overcrowding. So on all of those bands that I was talking about earlier, band 1, 2, and 3, there is a section. You could be given high priority, medium priority, or low priority for lacking a bedroom. So for being overcrowded. And I think it's helpful to go through what the law says about overcrowding, because it's not what you or I would think about when we think about overcrowding. It's very technical, and it doesn't seem very fair, put it that way. And when I explain this to people often get quite upset, because it's not what your ordinary person would think of when they think of as overcrowding. So the law on overcrowding is set out in the Housing Act 1985. And there are 2 different ways that people work out, that the council can work out what is overcrowding. And I've just put the sections there: the room standard and the space standard. So the room standard is that a household is overcrowded when 2 persons of the opposite sex must share a sleeping room. The children under 1 don't count at all. So you've got a situation where you think, oh, there's a family, there's maybe just 2 parents and 1 child under 1 in 1 room. And you would think, well, that's not fair, that's overcrowded. But actually children under 1 don't count at all. So if anyone's got an under 1-year-old, they according to this policy, they don't count, but they're very much there. And then the second standard is called the space standard. And that involves looking at the number of sleeping rooms or the floor area of the property. And so occasionally I said, look, you need to measure actually how big the floor area of the property is. And in this standard, under 10s are counted as half a person, and your under 1s aren't counted as a person at all. So in Hounslow's allocation policy, at the back, there's a little table which sets out, the number of people, the number of rooms. And whenever you're looking at these standards, if you look at them, what is, again, people find hard to understand is that living rooms are considered rooms which people can sleep in. So it's really hard. People will say, well, we're overcrowded, so and so sleeping here, and then actually when you work it out, because the living room is counted as somewhere you could sleep, they're not technically overcrowded. I mean, there can be some arguments with this. There can be some arguments because sometimes if it's like an open plan kitchen, that doesn't count as a living room. So you do need to just be careful what people have. But it's every time I do some advice on the phone about this, I end up having to go back to the table about the different standards and the different people and the different ages of the children. Because it can get quite complicated. And also it's just very disheartening for people because, you know, they know that they're overcrowded, they feel overcrowded, but quite often technically, according to the law, they're not overcrowded. So that can be really difficult. Okay, so I've put on here, I've put a 5-minute break for some coffee. Is everyone okay? Has anyone got any questions? Otherwise, we'd maybe just have a couple of minutes break and then come back and do an example. I'm going to take that as I think everyone's okay, and we'll come back in like 5 minutes, maybe.
Yeah, 5 minutes.
Have a comfort break.
So
Okay.
the time now is 20 to 11, so 11:15.
Yeah. Okay. See you in a bit. Hello. Is everyone refreshed?
I think so.
Excellent. All right, I'll crack on then. Oops, to minimize you all. Okay, so the next slide I've just put up here is just in terms of how you would approach trying to work out, you know, advising someone about these situations. And I've got an error there I just need to take off. Is that you need to know what the nature of the person's current accommodation is. So are you looking at a transfer? Are you looking at homelessness accommodation, temporary accommodation? And people don't always know. People get confused. You know, if you think about it, moving is one of the most stressful things. And, you know, if you're in a situation where you're being evicted and going to the council, you're moving in a really stressful situation, you're given an address and someone to meet to let you in. And often people won't necessarily know if it's, you know, if it's a private landlord, but their agreement is with Hounslow Council, or if it's a private landlord and the council have complied with their legal duty by providing a year tenancy. Sometimes it's quite hard to work out. So you often need to see, well, you do always need to see eventually, you know, the basis on which someone's being accommodated, because then you can work out, you know, is it a situation where it's a transfer? Is it a situation where it's homelessness accommodation, and actually there's a process called a Section 202 review about the suitability of the homelessness accommodation? Is it a situation where you've got to go down that route? But without getting to the bottom of the nature of the current accommodation, you know, you're going to struggle. And also there's something else to consider, which is that sometimes in terms of a transfer, it might be that actually someone might want to make a homelessness application. You know, is the accommodation so bad it's not reasonable to continue to occupy? And it's quite rare that that's the case, but again, it's something that you should probably consider. And then you're looking at evidence. So, you know, if you're saying that there's medical issues, that means there's a medical priority. What evidence do you have of that? And we talked a little bit about GPs, occupational therapists, people that have actually visited the property. And here, I mean, I think when I'm speaking to people, advising people on the phone, you know, it's sort of, at this point, you're thinking, you know, is it going to be at such a threshold you are going to get moved up a band? Or are you kind of giving someone unrealistic hope that they might get moved up a band? Also in a situation where, unfortunately, there's so little council stock, if actually what people want is a definitive reassurance that they're going to get council property rather than private rented, there is nothing in this allocation policy that would mean that you could guarantee that as an advisor if you're speaking to someone. So that's kind of quite, it's quite harsh, but I think it's quite a difficult and important conversation to have with clients about what their expectations are. And then if the council make a decision about a banding, but you think it's incorrect, the client thinks it's incorrect, there is a review procedure, and that is set out in the policy as well. You have a 21-day deadline. So for example, you've put in your OT report to the council saying that you want to be in band 1 because you're saying that the medical condition is life-threatening. Actually, they put you in band 2, but you get another medical report, or you just don't agree with how they've dealt with it. You have that right to request a review. Right, so I've got a couple of case studies here just to kind of have a chat through. So I'm going to just stop sharing this document, and I'm going to share just a couple of examples. I'm not going to pick on anyone or anything. It's just to have a little bit, try and see if we can just apply it to people. Right. Right, so can people see this? Yeah, good. Okay, so I've just put here just for training purposes. So we've got Mr. and Mrs. Khan. So we've been visited by a couple who have a secure council tenancy. So that's, you know, it's a really valuable thing. They've got a secure council tenancy. They've lived at the property for many years with their son, who's 15 years old. He's got a degenerative disease and has recently become a wheelchair user. The property is a 2-bedroom flat with the bathroom upstairs. There's a living room downstairs, but no bathroom downstairs and no space for adaptations. The family are unable to lift or carry the son upstairs. They want advice about what they can do to try and move and what options are available to them. So the first question that I put here was, what further information would you want to know about the family, if any other things that you would want to know that you don't know about them from the information that I've given? So I think you'd probably want to know, you know, what their views were about moving, maybe moving out of London, any additional needs the son had, any needs that they themselves had. We don't know anything about the mother and father, whether or not they have any needs. The next question I've put is what options are open to them to try and move. So in this kind of scenario, it looks like there would be, you know, the fact that he can't get upstairs to that bathroom is having a significantly adverse effect on their quality of life. So I think it would be arguable that they could ask for to be put into their band 2. But also arguably the property is not reasonable to continue to occupy, so they could make a homeless application. But I wouldn't have thought that's going to be suitable, given that they've got a secure tenancy, which is I'm assuming a certain amount of knowledge there. But the good thing about a secure tenancy is that it's extremely difficult for the council to evict you. They can't just decide they want to evict you on 2 months' notice. They have to show that there's a reason for eviction, but also that it would be reasonable in all of the circumstances for a possession order to be made. So that condition of it being reasonable in all the circumstances before a judge made a possession order means that, you know, you have a great security if you have a secure council tenancy. I've put here, what evidence will you need to try and assist? So here, you know, we've got the fact that he's a wheelchair user, but it would be really helpful to have something from an occupational therapist or GP or specialist, maybe a assessment of them as carers, just as much evidence as possible. And then I've put, what other services might you get involved? Other options for transfer. So it might be that, you know, with properties, you can do mutual exchanges. So both parties could decide they want to swap properties. They could look at whether or not they wanted to move out of London. You would probably want to see if social services were involved. So if there's a care plan for the 15-year-old. So you'd want to make sure that they were getting as much support with all of that as possible. Let me see if that's the answer that I put on my sheet, because I've got the answer on another sheet. I'm going to see if I've just missed anything off there. Give me a second. Yeah. Okay, right. So sharing my screen. Right, so the next one. Okay, hopefully you can see that. So this is Mr. and Mrs. Smith. This is again quite a sort of similar, not similar, quite a common example. They're living in a council flat with a secure tenancy. Again, that's a good position to be in. The flat's a 1-bedroom flat and they have 3 children who are 1. I sort of made a mistake with this yesterday. I think I meant 3 children who are 1, 2 and 5, but yesterday I said 1 and 2.5, but I think it's 1, 2 and 5. They want to move to a 2-bedroom flat. The current property has a living room, bedroom, kitchen and bathroom. So I've put on here, what further information would you need to be able to advise them properly? So what we don't have is we don't have the sex of the children. We don't have, someone said yesterday that, you know, we don't know whether or not the living room is a separate living room or whether or not it's included in the kitchen. So you might want to find that out. And you don't know if there's any medical needs with these children. So here you're assuming that, you know, there's no special educational needs or physical mental health needs with the children. So you'd want to find out a bit more about their circumstances. You'd want to find out a bit more about Mr. and Mrs. Smith's circumstances. You don't know if there's a disability there, if there's anything. You don't know. Yeah, so you need to find out a little bit more information before you could advise about that. And the advice, this is one of these horrible situations where the advice is likely to be that they're not overcrowded because of the ages of the children, and the fact that they're only counting as sort of half people or not counting at all. If they were in a one-bedroom flat and they've got a living room, it would probably be expected that Mr. and Mrs. Smith have one room and the children have the other. So that's, you know, likely to be, it's one of those very common but sort of difficult situations where you might be giving negative advice about what you can actually do in that scenario. Anyone got any questions about that? Okay, so just moving on then to the last example. So we've got Miss Poole. She's living in temporary accommodation provided by the council. She's been accepted as homeless and wants a council flat. Her current flat's a studio flat, but it's only temporary accommodation. She suffers from depression and has medical evidence about this, but she wants a permanent council flat. And the questions I've put here are, what are her chances of getting this and what would you advise her? So if you go through this, she is, she's accepted as homeless. So with Hounslow's accommodation scheme, she would be in band 2 already. So where it says here that she suffers from depression, because she's in band 2 already, she would need to suffer extremely severe depression as a result of the property, which meant that it was sort of life-threatening for her to be put into band 1. So you would want to explore that a bit further with her, but actually she's probably about as high up as she's going to get in band 1. And then the other problem here is that she's saying very definitively she wants a council property. And if you're advising her about Hounslow's scheme, you would have to be saying that there's nothing in this scheme that prevents her being offered a direct offer of something that was suitable, that was private rented accommodation. So, you know, you might, if there was evidence that the depression, you know, there was a link between the current property and her depression, you might be able to get a move to another property, but you would not be able to guarantee her as her advisor, you wouldn't be able to guarantee her that she would be placed in council accommodation. So that's kind of, I think that's quite typical of like a really, really distressing situation that when you're advising people, you find yourself in quite often, because, you know, no one's going to be denying that the constant moves and private rented accommodation is having a toll on her. But the way this scheme works is that she would be able to be offered private rented accommodation. In terms of accommodation having effects on people's mental health, I mean, there is some quite helpful case law about situations where former asylum seekers have been in property that has been very sort of closed and dark and reminding them of prison cells and things like that. So if you ever get a case where you have accommodation that reminds someone of something traumatic in the past, that can be a link between the property and depression or mental health conditions. So it's quite interesting in terms of area of law. Okay, so that was a bit of a whistle-stop tour of Hounslow's scheme. I'm really happy to answer sort of any general questions that you have. I've got another slide, actually, one other slide. Maybe we'll just if you have questions about the case studies. Has anyone got any questions? No, that's fine. I will just move on then. So I just put here a slide just about the situation with legal aid and the law centre and advising about allocations. So legal aid's available for allocations cases, so cases about reviews and things, if the person is homeless. So that's quite a high threshold. What we tend to do about allocations is we will do some advice on the telephone about the allocations, because quite often it's a case of someone needing some guidance and then being able to go off and get the evidence and update the council. But if there's any doubt, please email or call for advice about this. I'm going to put my emails on the next slide, but also the Law Centre's website has how to make a referral to the Law Centre. Quite often with allocations cases, I'm giving quite negative advice, and that's quite hard, but sometimes it can help people to work out, you know, what their options are. The other thing is that I know this project that Toby's working on is a campaigning project, and if they're, you know, this is a great thing to, you know, if you're campaigning for additional social housing, you know, the fact that Hounslow will offer private rented rather than social is a, you know, a point from campaigning, from my point of view. But do contact the Law Centre if you think that there's a case that needs legal advice. And I've put some resources up here. So Hounslow is actually quite good in that they do have their whole policy and every single step that they should be taking, and what to do if you've got a complaint, what to do, how to do a review. That is all on their website. And there's also quite a good frequently asked questions section. The Housing Act, I've mentioned a few places as we've been going through. That is, I've given you the link there, and also to the Homelessness Code of Guidance. And I've also just given a link there to the Legal Aid Financial Eligibility Calculator. If you're not sure whether or not someone that you're helping or yourself is eligible for legal aid, that looks at the threshold. The thresholds, it is quite complicated, but essentially if you're in receipt of universal credit or an income-based benefit, you're likely to be eligible for legal aid. If you're in a situation where you're working part-time or working on a relatively low income, you can find yourself just slightly above there. In those circumstances, we'd probably give some advice on the phone. And that is my my email address there. But that's kind of a whistle-stop tour of Hounslow's policy. I'm very happy if anyone has any questions to answer those, or if any other comments that anyone wants to make. Richard, you've got your hand up.
Thanks. Yeah, I think my question is probably sort of before we get to this point. I work in the LGBT community, and the nature of our community, particularly for younger people in house shares, etc., is that can be quite geographically dispersed around around London. That people's friendship groups and therefore house shares might it might be across many boroughs over a period. How does that fit with demonstrating a connection to a particular borough? So, okay. I suppose I'm thinking about a scenario of, say, somebody in their 30s, perhaps getting ill or losing, being unable to support themselves in the private rental sector independently. Where do they go if they've been bouncing around? It's a really good question.
Yeah. So really, it will depend on the individual scheme for the borough that they want to apply to. So for Hounslow, you need to have been living in Hounslow, or if you're a care leaver and you've been placed anywhere else in London, or you've been in care where Hounslow are the local authority in which you were in care with, you can then join Hounslow's housing register. In Ealing, you need to have been accommodated living in Ealing for 5 years. I think that there's probably an exceptional cases panel where you could consider something, you know, in sort of compassionate circumstances, but I'd want to just check that. But it's very dependent on where that person is. So, for example, if as you say, if you've been moving around London and you just happen to be in Southwark, but actually you've got friends or connections in Hounslow, you're going to struggle to make an application to Hounslow. It's not very satisfactory.
Yeah. So is there anything about counting back to when you last had you say Ealing's 5 years living, and how many years was Hounslow for?
I think I'm not sure. I think I'd need to just double check that. It'll be in the policy. Yeah. There's two separate routes. There's, if you're homeless and actually you would be dealt with under the homelessness scheme of things, you can make an application and Hounslow would deal with that, even if you weren't in the borough at the moment. So, for example, if you were fleeing domestic abuse and you had to go to Hounslow and make an application, they would deal with that. But then it's about how they then put you on the scheme to be allocated permanent housing. I would want to I'll look into that a little bit more for you, Richard, because I'd want to just go into a bit of detail with Hounslow's scheme. But it can be tricky. People can be, there's quite a lot of situations where people are homeless, have applied to Ealing and have then been placed in Hounslow and then are kind of moved around between the two, and the local authorities argue with each other. So it's not quite answered your question, but I will look at that a little bit more for you.
I think I've come across cases where people have been placed in temporary accommodation in Hounslow, and then from Ealing, but I think the cross-border stuff. I take it there's no concept about somebody being a resident of London.
No, that would be brilliant. Actually, that would be a good campaigning point, wouldn't it?
Yeah.
HPPC has his hand up. Hi. I think
good morning, everyone. Good morning, everyone.
Hi.
Just want to ask you, my name is Omar. I represent Allocation community group from Somali community in Hounslow. I just want to give you, it's a question on a brief case. If somebody was disabled and they were providing medical report to the Hounslow, but they were kept in band 3 for a long time until the MP and the councillors got involved. But still, they were, even though the occupational therapy went to the house and told them that they need to be moved because it was a risk of, and they had an evidence of this person falling from the stairs. Then one of the council members just realized that the mistake that the Hounslow made, and they were put on band B on high medical priority. But the Hounslow realized that it's the mistake that this person was suffering all this time and he was in that band. So now my question is, if this person is in band B and still he has not got a house and the MP and the councillors are still speaking to Hounslow, and how long does he wait until it becomes like you can take legal against the Hounslow, provide this person with the place?
I mean, the question would be if they've then applied it, and you're now saying he's correctly in band B, he's gone up to the medical that he should be should be in. So long as they're acting lawfully and they're, you know, in priority, there's not going to be very much else you can do. I mean, one thing that might be worth looking at is if there was a complaint about the fact that he should have been moved up earlier and that was something to do with maladministration, then you may be able to go through the formal complaints process to see if you could get the band B brought back to the time when he needed that medical priority. So occasionally they will look at things like that, and that then might mean he goes, because within the bands you're on a priority according to the length of time that you've been on the band. So there might be an argument that, you know, that the banding could be brought forward, and that he would then have a quicker sort of chance because of that. But I mean, I think in that kind of scenario, you've kind of done all that you can. You've got, you know, MPs, councillors involved. But it might be worth doing a formal complaint.
Thank you.
Anyone else?
Just quick one from me, long shot, but are you aware any other boroughs in London do the direct offer rather than through allocation scheme like Ealing?
Do you know what? I'm not. I'm not sure actually. I was really surprised when I came to look at this because, as I said, I do Ealing a little bit more than I do work with Hounslow, and it's quite recent. But I mean, I can see why they've decided to do this, because you can, you know, when I was doing the Ealing session yesterday, people get frustrated because they're bidding and not getting anywhere. So.
Thank you.
Hi, Vicky, it's Margot.
Hi.
Hi, just a straightforward question. You said that the medical evidence for clients shouldn't say that the client has preference or benefit from something. What kind of words we should use, or we should pass to the doctors if possible?
Yeah,
how it could be phrased?
Yeah, it's very tricky. I write instructions to doctors asking for medical reports all the time, and I say, can you address X or Y, and they still come back with things that are unhelpful. So, but what I tend to do is I ask the doctor for a list of medical conditions, whether or not they visited the property, can they explain, you know, whether or not that medical condition is linked to the condition at the property. And very specifically, when you're asking the doctor for that letter, say, look, please, I need you to address these points. And sometimes the doctors will just come back and they'll say, yes, no, yes, I can't say. And actually one of the reasons they often report back what the client has said is that they haven't seen the property. So if the doctor actually hasn't happened to have gone and done a home visit or seen the property, you know, they're relying on what the patient has told them. So they can be a bit reluctant to do that. So it's tricky. I think the lady was saying about an occupational therapist, and actually they do tend to go into properties more because, you know, they're looking at adaptations and how people are using the property. They can be a good source of information. Or, you know, sometimes the mental health teams, they have home, you know, the emergency teams or the home recovery teams, they have people going. So it might be that the GP is not that, you know, sometimes just think about it a bit creatively. It might be that the GP is not the best person to give that evidence.
Okay, thank you.
Okay. So I think I have Richard's question slightly outstanding, but does anyone else have any questions that I can help with? As I said, Toby will send the slides around, and if you do get stuck or you need some help. Oh, hi, Emma.
Yeah. Sorry. You told me like you can make the complaint. Do you do it directly to Hounslow, or?
You usually do it if you follow, if you go to Hounslow's website, they have a section on making complaints.
Yeah.
And you follow the procedure on there.
So is there any way I can email you? The person I'm talking to, actually, it is.
You can email me. I'm not going to guarantee I'll be able to take the case on, but I'm very happy for you to email me so we don't go into details. And that goes for, I think it was Umesh as well, who had a sort of personal query they wanted to to speak to me about.
Sorry,
So
Vicky. Yeah, I'll
No, that's
email
fine.
you the whole detail.
that's the danger of doing training. You drum up business.
Sorry about that. Sorry.
That's fine. That's fine.
Sorry, everyone. Sorry, really sorry.
No, that's fine. And same for you, Amash, as well. That's absolutely fine if you want to email me. Okay. Oh, you're on mute, Toby, I think. Or something strange has happened. You've lost your sound. Can't hear you. Okay, all right. We'll leave it there. Thank you. Have a nice Friday. It's nearly the weekend. Take care. Bye-bye.